Welcome everybody to today's webinar on commonhold. I'm Christabel Smales and I am a knowledge lawyer in the commercial real estate team here at Cripps. And I'm delighted today to be able to welcome our speakers, Philip Rainey KC from Tanfield Chambers. Philip's practice straddles the commercial and real estate divide, encompassing all aspects of real property, commercial landlord and tenant, as well as the residential landlord and tenant enfranchisement and service charge elements, which places him extremely well today to share his thoughts on these extensive reforms. Also, Anna Favre is with us. She's a partner in our residential estates team here at Cripps and also leads up our landed estate sector. Now, today's webinar is entitled Beyond the Bill, the Journey to Commonhold Starts Here. Perhaps we'd be better off saying the long journey to commonhold starts here. And there is some degree, I think, of irony in the fact that on the 27th of January, our Prime Minister took to TikTok, of all places, one of the most centralised digital platforms in the world, to announce a bill that, in his own words, will dismantle a feudal land leasehold system that dates back to medieval times. Now, setting aside what is a fairly strong helping of historical whiplash, I think it's fair to say that we haven't seen a more dynamic period of reform in more than 100 years, and it is extremely difficult to discuss commonhold in isolation. I think one of the key common themes that emerges is that in order to make commonhold the tenure of choice, what the government needs to do is disincentivise the use of leasehold, and it has a number of legislative arrows to its bow in this regard. We've got the Leasehold Reform Ground Rents Act 2022. That act came into force on the 30th of June 2022 and banned ground rent in new long residential leases. We've got the Leasehold and Freehold Reform Act 2024, referred to normally as LAFRA. That reached royal assent, you'll probably remember, in the parliamentary wash-up of 2024. And whilst obviously not largely enforced yet, it's very much a key part of the reforms, introducing reforms to lease extension rights and also a ban on the grant or assignment of certain long leasehold interests in houses as well. More recently, the Renters' Rights Act 2025, that received royal assent in October, and it's essentially ripped up the rule book in the private rental sector. The primary aim, of course, is to provide a greater degree of certainty, security of tenure for tenants by phasing out assured short-hold tenancies and banning no-fault evictions. And the main changes in relation to that act come into force on the 1st of May. And then finally, and of course, certainly not least, in the context of today's webinar, we've got the draft Commonhold and Leasehold Reform Bill 2026, which at 193 pages embodies an extremely complex set of reforms which are set to reinvigorate commonhold tenure and ban the use of leasehold tenure for most new flats. Now, whilst the bill, the policy driver is, of course, to give homeowners much greater certainty and control over their homes and to tackle bad practices in the leasehold system, the wider purpose of the reforms is to give developers the flexibility to design commonhold sites and decision-making within them, and to account for the full spectrum of how different parts of sites and different buildings on large sites can fit together. So the bottom line really is that, except for sole commercial premises, these new reforms are going to impact almost all parts of the property sector, whether that be existing and new residential developments, including mixed use, which we'll go on to talk a bit about today, real estate finance, site setup, plot and conveyancing documentation, the due diligence process itself, as well as obviously the conveyancing process, and the land registry and companies house processes as well. So it's going to have a hugely wide impact on all stakeholders in the real estate market: leaseholders, lenders, investors, and developers. And that's across the residential and commercial sectors. Now, before we go on to talk a bit about the key provisions of the Act and the practical implications of those provisions, there are just 3 points I wanted to make. The first one is that commonhold is not new. It's no surprise, or will come as no surprise to you, or no secret, that it has struggled to gain traction. The current bill, which is referred to quite often as Commonhold Mark II, is a reboot of the original Commonhold legal framework, which was introduced in 2002. But there are fewer than 20 commonhold schemes currently in England and Wales, so there's very few people with actual practical experience of how these schemes worked. And it's really hoped that this new bill will address some of the legal flaws which have historically been barriers to commonhold being more widely adopted. The second point I wanted to make is that what we currently have is a draft bill and not a bill, and that's quite a significant distinction. It's quite rare for a bill to be produced in draft form, and it's evidence in of itself, really, that such major and complex reforms require additional scrutiny, and that the government recognise that. And I know that Philip will go on to touch on that a little bit later. The final thing I wanted to mention is that whilst the reforms we're going to discuss today are focused on residential property, the government's guide to the draft bill does note that there are options for reforming commercial leaseholds as well, and that will be something that will be continued to be explored by the government and the Law Commission. So it's a case of watch this space. In terms of structure, we've obviously got a huge amount to cover, and we've decided to split today's seminar into 3 parts. Firstly, we'll look at the nuts and bolts of the new bill and the key provisions. Secondly, we're going to look at the practical implications and challenges that developers will face, both in terms of structuring current and future schemes. And then we'll go on to conclude by weighing up the pros and cons of the reforms and also discuss what we expect to happen next. So, Anna, I think perhaps starting with you, the obvious question really in terms of looking at the bill and the nuts and bolts of the bill is, why are we seeing a reinvigoration of commonhold now?
I think, as you identified at the beginning of this session, there are quite clearly articulated defects in the current legislation in the sense that it's not fit for more complex schemes. So where, for example, you have mixed-use premises or multi-block developments or anything of that nature, it doesn't have sufficient flexibility within it to really accommodate more modern forms of development. So quite rightly, the government has identified that that needs to be reformed, which culminated in 2020 with the Law Commission in its 13th programme of law reform being tasked with reinvigorating commonhold to look at how it could become fit for purpose, fit for the future. Fast forward to where we are today, and clearly anybody who has even a passing interest in real estate will be aware of the narrative around leasehold, which is widely perceived to be under sustained pressure from leaseholders affected by this as a toxic form of tenure. Now, there are arguments both for and against leasehold as a structure, but nonetheless, the government has made it quite clear that it intends to gradually phase out leasehold and in its place have commonhold, and clearly that is where we are today. It's happening.
And I mean, the million-dollar question, there are lots of million-dollar questions within this particular frame, but how the biggest one of all, I suppose, is, how does commonhold work?
Yes, so the concept itself is fairly straightforward. The basic premise is straightforward. It's freehold ownership of individual flats, which is a much more common form of ownership if you look on the continent or the States, or even in Australia, which under the strata system. So rather than having the concept of a landlord and tenant with the associated diminishing lease term and all of the negative connotations that we have now identified, you have individual ownership, and then there is collective responsibility for the communal areas within the development. So the development itself will be held by the Commonhold Association. So there's a nice little neat package there, which is very user-friendly at first blush. But as you've already identified, the sheer length and, excuse me, complexity of the bill shows just how detailed it is.
So it sounds simple, but it does take the first 81 pages of the bill to explain the mechanics of commonhold ownership. I think before we go on to look at it in a bit more detail in terms of what it means in practice, it's worth just examining the sort of the nuts and bolts of commonhold ownership itself.
Exactly, Chrissy. I mean, I think the phrase is probably beguilingly simple. As with everything, the devil is in the detail, and the sheer length of the draft bill is in itself evidence of the complexity. It's essentially a community of homeowners who have a freehold ownership of their individual unit. Note that it's units, not flats, so interesting change in terminology there. And then there's collective management of the communal areas. The Commonhold Association is a company limited by guarantee, so there's no share structure, but each individual unit holder will be a member of it and therefore have an associated voting right. The Commonhold Association has a legal personality, so as such it's able to have title to the communal areas. And in the normal way, as you would expect with any freehold and leasehold structure, it will be registered at the land registry as such. So because of the sheer lack of commonhold developments that have been created, I think you said there's 20? There isn't that much precedent as how the land registry deals with this, but it will be interesting to see if they get up to speed with some of the changes that are going to be introduced, and if it throws up any issues from a title perspective. Each unit holder will be able to elect a director to manage the Common Hold Association. I understand that potentially through regulations there will be ability for third parties to appoint directors to the Common Hold if needed. But one would hope that the idea of having collective responsibility in an interest which is your home would actually encourage people to step up and to take on that responsibility. We then have the rule book. So essentially that's the guide to what you can and cannot do within the common hold development, similar to what you might expect to see in a lease. That's known as a common hold community statement. In the context of developers, for example, that will be drafted at the outset of the common hold. It's therefore going to be interesting, isn't it, to see the extent to which you will add in what are called local laws in order to make the CCS fit for purpose, so appropriate for any given development. Some interesting drafting coming down the line then, I think. We also have a new concept, which I think Philip will cover a little later on, which is around sections. Now, one of the criticisms within mixed-use buildings is the fact that it's one size fits all. It didn't have sufficient flexibility to allow the complexity of those types of schemes to really flourish and to fulfil their purpose, which is both commercial and residential tenants. Sections allow both the apportionment of cost but individual voting rights applicable to the respective parts of any development. So, for example, you might have a separate set of rights in respect of commercial tenants, commercial unit holders where applicable, and then equally you would have similar rights in relation to residential. So the idea there is that rather than having to pay towards a cost from which you derive no benefit, you would actually have a fairer, more compartmentalised structure for mixed-use developments. Another criticism of the current legislation is the prospect of the Common Hold Association becoming insolvent. There is now a provision, as you've mentioned, for a compulsory reserve fund, and that will be subject to new rules, which essentially means that you have a slush fund to deal with any emergency repairs at the building, which I think will be a helpful mechanism, but it could almost certainly drive costs up, and that's something which we can touch on a little bit later. An interesting point for any of our developer clients is that developers will lose the right to appoint their own directors at the point at which at least 50% of the units have been sold. Therefore, the majority of voting rights will be with the unit holders themselves.
I think we'll set part one aside for one moment and we'll move on to look at part two very briefly. So new leases obviously in residential houses were of course banned with limited exceptions in 2024. Now part two of the bill deals with the ban on the sale of new leasehold flats. Philip, perhaps you can explain a little bit more about how the bill envisages this working in practice.
Yes, thank you. I mean, the common hold is now going to be the default tenure for new flat ownership, because as we'll see, new developments are going to be common hold. So part two of the draft bill introduces measures to restrict the grant or assignment of long leases of new flats, and they will have to be common hold. And this ban, importantly, is going to apply not just to new buildings, but also to existing buildings if they don't currently contain a long leasehold flat structure. There are going to be some exemptions from the ban, which unfortunately is going to create some complexity. So there will be permitted leases within the common hold structure. And the known examples at the moment are shared ownership leases, which is a very important change because the inability to deliver shared ownership was a flaw in the previous common hold scheme. You can have lease-based home finance plans, including Sharia-compliant finance, and home reversion products. So those are three known categories of leases which will be permitted. And as we'll also see, when you get to the conversion from existing leasehold schemes into common hold, there will be non-consenting leaseholders, and they will be permitted to carry on with their lease, at least temporarily. So that's a fourth category. However, it doesn't mean that they will carry on with the same rights that they currently have. Importantly, because of the incompatibility between the current protections for leaseholders with service charges and the commonhold assessment under the Commonhold Community Statement. The protections under the Landlord and Tenant Act 1985, for example, will not apply to tenants. They will get different protections and they'll get different rights. But they won't, for example, be entitled to challenge a service charge in the same way. They won't be entitled to apply to have a statutory manager installed. Now, we do know that the ban is going to capture both new build developments and newly created flats for sale within existing buildings, but there are things that we don't know and which are going to be potentially controversial. For example, when is the ban going to commence? What are the transitional arrangements going to be? And what is the final list of exceptions? And these are not in the draft bill. They'll either be added when the bill becomes a proper bill, or it will be dealt with by regulations. The one thing that we do know is that the ban will only come into force once the reformed commonhold framework is fully operational and the market has had some time to adapt to it. So it won't be a chaotic big bang as far as we can see. The commonhold system will come in, it'll bed in, and then the ban on leasehold flats will be implemented.
Philip, I think the obvious question is, well, what will happen to existing leases?
Existing leasehold flats won't be affected. So if you're in a block, which is a leasehold block now, and it's not converted, then you can sell your flat on lease, as you can at the moment. You will be able to apply under the 1993 Act, the Leasehold Reform Housing and Urban Development Act. You'll be able to apply for a lease extension, which under LAFRA will be an extra 990 years. You will have your existing rights under the Landlord and Tenant Act 1987 to vary an existing lease, and new leases of flats in that block will continue to be able to be granted. What is going to change is that there's going to be provision to convert to the commonhold system. And again, correcting one of the flaws in the current system, it's not going to require unanimous consent. So it is possible, if you're a leaseholder in a block and the majority want to convert and you don't, that you will end up in a commonhold block simply because you have been, in effect, outvoted. And one final point, which will be important to many of the developer clients, the ban is only going to apply to flats for home ownership. So build to rent, social rented housing, dedicated student accommodation, those are going to fall outside the scope of the ban.
Conversion is quite a sticky issue, and we will obviously go on to talk a bit about that in due course. Moving though from one sticky issue to another, Anna, ground rent has traditionally obviously been a feature of long residential leases. So that's periodic payments made to the freeholder in addition to an upfront premium. Historically, of course, the level of ground rent as a proportion of the value of the relevant flat or house has been very low. However, we have seen the practice of including escalators develop, and the impact of those escalating ground rents has prompted a government response to tackle what they refer to as the unregulated and unaffordable ground rent charges. And the capping of ground rents has been another headline-grabbing element of this new bill. The Ground Rent Act 2022 already prohibits ground rents being included in new leases. So those are those leases granted after the Act was implemented, June 2022. What does the commonhold draft bill do with regards to ground rents in existing leases?
Well, it applies to what's described as regulated leases in the same way you've alluded to, Chrissy, in the Ground Rent Act 2022. It will apply to leases of dwellings of more than 21 years, which clearly that's the magic number, isn't it, in terms of statutory rights applying, which have been granted for a premium. And what it will do is introduce an immediate cap, once it's in effect, of £250 per annum, being phased out over a period of 40 years to a peppercorn ground rent.
And the key thing with these reforms is that they necessarily have an impact on existing contractual arrangements, and this is the sort of crux of this. It's not something that the government undertakes lightly, obviously. What's the underlying policy intent for this change?
I think it's really around the perceived unfairness of ground rent. Unlike service charges, where there is at least a notional return on your investment, which is in the form of repair, maintenance, and so on to buildings, there isn't an equivalent. Ground rent is purely an income stream, is how it is perceived for the landlord or for the investor or even pension funds. But it's very embedded in the psyche of institutional investors, including pension funds. So I think the government was cognizant, and indeed is cognizant, of the impact upon that sector if there was an immediate and outright ban of ground rent, as was proposed a few years ago when it went to consultation.
Clearly controversial. Any further thoughts at this stage?
I have several. So there's over 5 million estimated leaseholder dwellings in England and Wales, and in fact the government explanatory notes alludes to this. 3.8 million of those are estimated to pay ground rents. Now, ground rents can come in the form of £50 per annum fixed, or they could be doubling ground rents, perhaps linked to RPI. There could be all kinds of punitive levels of ground rents applicable. So the one-size-fits-all approach that the government has adopted here may simply not be appropriate in the circumstances. I'll leave that question hanging, but clearly this was triggered by the leasehold houses scandal from 2017, where unmortgageable, unsellable properties became commonplace for exactly the reasons we described. I think there's no doubt the perception of unfairness is very much the driver. I think leasehold has developed, rightly or wrongly, a reputation of having quite deep inequality of bargaining power. And of course, statutory intervention in private contracts is justifiable in the context. So the government would say in the context of real estate, because of that inequality of bargaining power, but also the very long duration of the contracts in questions, i.e. leases. On one estimate, the value transfer, and we are talking about a value transfer from freeholder to leaseholder or from investor to leaseholder of 10 to 12 billion at the end of the 40-year term. And M&G, of course, who are a huge institutional investor, talking in their own right of potential losses of 230 million. So pretty significant, but I think the government is seeking to balance its policy initiatives and agenda with a phasing out to make the blow somewhat softer. I think in terms of sentiment and certainty in the market, though, the impact is already being felt. I think all of us, who deal with both commercial and residential tenants will be fully aware of the impact on that. Legal challenges, I mean, Philip may have something to say on that later on, but I think almost certainly there may, or perhaps not, but there may certainly be a judicial review on the basis it's not compatible with Article 1, Protocol 1 of the human rights. So we shall see.
And final question on ground rents. It seems that timeframes generally are quite up in the air, but it seems likely that the capping of ground rents may come into force late in 2028. Will the caps apply retrospectively?
No. There was a thought that they might when it went to consultation some years ago, but I think the government recognises that the impact on the sector would be far too huge. So really, the approach that's been taken is a bit to be balanced.
And Philip, let's just briefly pick up on the last two key changes introduced by the bill, and they revolve around a fairer approach to enforcement and a rebalancing of the relationship between landlord and tenant. Taking each one in turn, rent charges first. Two questions: what are rent charges, and how does the bill affect them?
There are various forms of rent charge, but the one which you'll come across and which this is concerned with is what's called a variable estate rent charge, which is an annual or periodic sum charged on usually freehold land, and it's commonly used in practice as a way of providing for managed estates. It's a way for freehold owners to contribute what would under a lease be a service charge for communal maintenance of amenities such as roads and drains and sewers and so forth. And they've become quite prevalent, mainly because local authorities are not in a position to adopt, for instance, the estate roads and parks and so forth. What the bill does is two things. I mean, the first important thing is that it repeals some provisions which are found in the Law of Property Act of 1925, which aren't widely known and understood, but which give extremely strong, arguably draconian rights to the rent charge owner, that's the person who receives the money, to remedy non-payment. Under the current law, they have the right to take possession of a property. So they can take possession of a freehold house until the arrears are cleared. They can grant an overriding lease of the house to trustees, and they can appoint a receiver, very much in the way that a mortgagee can. And the short point about the bill is that these rights and remedies are simply going to be removed from the statute book. So what that means in practice is that rent charge owners they'll still be able to charge the sums, they'll still be able to recover the arrears, but they'll have to use more normal proportionate means, such as cost recovery clauses. They can sue in the court for debt. In theory, they could serve a statutory demand in bankruptcy if enough was owing. What they won't be able to do is, in effect, take people's houses away. The bill also, the second thing that it does is it builds on some changes which were made in LAFRA but which aren't in force yet, which require, among other things, rent charge owners to serve notices demanding payment of arrears, which include specified information, giving a breathing space of 30 days before enforcement action can commence. And the intent of these reforms, of that part of the reform, at least, is to make sure that people don't end up on the wrong end of enforcement action without actually realising that a bill was due.
And Philip, will these changes affect commercial property as well as residential?
The change, it depends which part of the change I think that you mean. Certainly the key change of removing the power to take possession and so forth, that will certainly affect commercial property.
And in a similar vein, the bill seeks to abolish forfeiture in non-residential leases. What's set to take its place?
Yep, that's absolutely right. The long-hated right of a landlord to forfeit is going to go. So, as most people know, under the current leasehold system, a landlord can terminate a long residential lease for breach of covenant by the mechanism of forfeiture. It's widely criticised for its severity, so the forfeiture can, in principle, be out of all proportion to the breach. It could be a small sum of money. And if a lease ends up being forfeit, then the homeowner loses their flat or house, the mortgagee loses their security, and the landlord gets a windfall because the landlord gets the entire value of the property, regardless of the severity of the breach or the amount of money which is due. And that's widely regarded as being inappropriate in the 21st century. So what the bill does is it abolishes forfeiture for both new and existing long residential leases, and it replaces it with a statutory lease enforcement regime, which importantly has much greater judicial oversight. So under the new scheme, landlords won't be able to act unilaterally. If a tenant's in breach, the landlord will have to satisfy statutory conditions, and then they'll be entitled to apply for a court-ordered proportionate remedy. And it will be the court which decides on what to do, considering factors such as how serious the breach is, whether the breach can be rectified, overall conduct, and so forth. And the court will have much more flexibility than under the current forfeiture system. So in principle, it can, in an extreme case, terminate a lease or a sublease, but, and this is obviously much more likely, it will make some sort of remedial order specifying a time frame in which the person has to complete specified action to remedy the breach. And there'll also be capacity for an order for sale. And that's important. It sounds like it's the same thing as forfeiture, but it's not, because if there's an order for sale made and it goes through, then the landlord will be compensated out of the proceeds, but the leaseholder gets the balance. So the windfall is eliminated, and similarly, a mortgagee would also get the balance. So that's a much more structured and balanced approach, the government thinks, to lease enforcement than the ancient system of forfeiture and relief from forfeiture. There's also going to be a floor, if you like, to exclude minor breaches. So there are thresholds which are going to be set somewhere between £500 and £5,000 for money, a failure to pay money, such as ground rent. So failure to pay low amounts of money will not permit landlords to use the new regime. and they'll be limited to existing civil debt recovery provisions for those sums.
And is it likely that we'll see these kind of changes for commercial leases as well?
Maybe, maybe not. The government and the Law Commission are continuing to consider reform in respect of commercial leases. The main difference with commercial leases is that they tend to be much shorter than residential leases, and you have a highly active tenant in many cases. We know the concept, for example, of the squat shops and pop-up shops and so on, and illegal changes and unlawful changes of uses of retail units. And the ability of commercial landlords to re-enter peaceably under the current system of forfeiture is a much more valuable right than it is in long residential leases, where that is almost always unlawful already because of the Protection from Eviction Act of 1977. So I think the government recognises that commercial leases are in a different category, but they are considering reform, and it certainly occurs to me that in enacting a new substitute regime for terminating long residential tenancies, they could in effect use it as a test bed for potential reform to commercial leases.
Thanks, Philip. Well, that's the bill in quite a large nutshell. Crucially, what does it all mean in practice? As always, the devil is in the detail. I hope you found today's discussions useful. Please do keep an eye out for part 2 of this webinar series, where we'll be looking at the practical implications of commonhold for developers.